Thank you, Chair, and thank you to all witnesses for your attendance and participation. Without limiting and without reflecting on the seriousness of this particular study, there was a decision that was released by the Supreme Court of Canada last Friday that is very disturbing on its facts and its implications moving forward for those being prosecuted with child sexual exploitation related offenses. And for that reason, I am asking for the indulgence of the witnesses while I intend on moving a motion. Mr. Chair, this motion was put on notice this past Monday, November the 3rd, 2025, in both official languages. I wish to read the motion into the record at this time. That given that the Supreme Court of Canada removed mandatory minimum sentences for offences related to child sexual exploitation and incorrectly ruled that these mandatory minimum sentences were cruel and unusual, and given that the premiers of Alberta, Saskatchewan, and Ontario, as well as the leader of the official opposition in Manitoba, have all publicly called for the use of the notwithstanding clause to overturn this decision, the committee call on the government to invoke the notwithstanding clause to reinstate these mandatory minimum sentences for child sexual exploitation, and that this be reported to the House. So, unfortunately, the decision itself is some 70 pages long. And approximately 1 page of that 70 pages is actually devoted to a description of the facts that were read into the record and accepted by the original trial judge in the finding of guilt. And I think it's important that this committee and Canadians who are watching these proceedings truly appreciate the heinous nature of the facts the Supreme Court of Canada was faced with. For the record, I am reading from paragraphs 9 and 10 of the decision. Decision is known as the Quebec Attorney General versus Senville. Paragraph 9. Louis Pierre Senville pleaded guilty to 1 count of possession of child pornography, section 163.1 sub 4 sub A, and to 1 count of accessing child pornography, section 163.1 sub 4.1 sub A. He admitted having been in possession of 475 files, including 317 images of children constituting child pornography. Of those images, 90% were of young girls between 3 and 6 years of age, some showing victims being subjected to acts of penetration and sodomy committed by adults and minors. Mr. Senville admitted that he had acquired these images through specialized sites and that he had possessed them for 8 months. He accessed these images for 13 months. Mr. Senville is a former soldier who was 28 years old and had no criminal record at the time of the sentencing decision. The decision noted that he cooperated with the authorities and complied with strict release conditions. Paragraph 10. Matthew No pleaded guilty to 1 count of possession of child pornography and to 1 count of distribution of child pornography. He admitted having been in possession for 13 months of 531 images and 274 videos of child pornography, most of which were of children from 5 to 10 years of age being subjected to sexual abuse, such as fellatio and vaginal and anal penetration by adults. Mr. No used specialized software to access that material, make it available, and wipe out any traces of it. Now, this decision, Mr. Chair, was released last Friday. From last Friday until earlier this week, there was absolute deafening silence from the Liberal government, particularly Prime Minister Carney and his Justice Minister, Sean Fraser. In fact, Mr. Carney, Prime Minister Mr. Carney, was very active on his social media over the weekend, including last Friday, highlighting all the photo ops of he in Asia on his trip, and not one mention of a decision that has rocked this nation. Justice Fraser, absolutely nothing until confronted in the House by opposition members asking for his immediate use of the notwithstanding clause. Now, we've heard, as I've indicated through the nature of the motion, how various premiers and other leaders have reacted. Now, to be fair to Sean Fraser's office, there was a spokesperson who did utter a statement on Friday denouncing child abuse and exploitation generally. The statement remained non-committal on whether the federal government intended to challenge the ruling. However, in Justice Fraser's home province of Nova Scotia, the Provincial AG and Justice Minister Scott Armstrong issued a blunt rebuke on Saturday, calling the judgment deeply troubling and demanding action. He stated, "Nova Scotians should be able to expect that sentences for those who commit horrible crimes will protect the public and not leave victims feeling more vulnerable," Armstrong said in an official government statement released on Saturday. He says, "This ruling raises serious questions about whether the punishments will truly reflect the severity of those offenses and the pain they inflict. Mandatory minimum sentences send a clear message that exploiting children is among the most serious crimes and will be treated that way." Armstrong added that he would share his grave concerns with Fraser and urge Ottawa to take action to ensure our justice system continues to protect the most vulnerable, particularly children and youth. Alberta Premier Daniel Smith, Ontario Premier Doug Ford, and federal Conservative leader Pierre Poilievre each condemned the decision in separate posts on X. "This decision is outrageous," said Premier Smith in an X post shortly after the Supreme Court's decision was rendered and made public. "The possession of child pornography is a heinous crime, and even a one-year minimum sentence is already far too lenient." Smith says she is calling on the federal government to immediately invoke the Constitution's notwithstanding clause to overturn this ruling and ensure the protection of our children. In an ex-post similarly timed to Smith's, Ontario Premier Doug Ford said, "I can't believe it. The Supreme Court ruled against one-year mandatory minimum sentences for the possession and access to child pornography." Like Smith, Ford also called for the federal government to intervene, saying that the notwithstanding clause was designed to protect the will of the people, before demanding that the federal government overturn this decision immediately. Pierre Poilievre went further, pledging legislative action if elected and calling the court's decision dead wrong. Child porn users must face mandatory prison time. The Supreme Court ruling today removing those penalties was dead wrong, the opposition leader wrote on Friday before promising that a future Conservative government would use the notwithstanding clause to protect the rights of children by locking up child porn users with mandatory prison time. In today's one of today's papers, there was a heading in a story that says, "Sean's gone wrong. Use notwithstanding clause in wacky child porn ruling." If there ever was a court ruling calling for the use of the notwithstanding clause, it's the debacle issued by the courts last Friday. Yet the Carney Liberals are saying that they won't overturn that politically motivated and poorly thought out decision. Justice Minister Fraser was asked about using Section 33 of the Charter to override the court several times on Tuesday and said no, he wouldn't do it. In a shocking 5-4 decision last week, the majority ruled that the mandatory minimum sentence of 1 year was cruel and unusual punishment and a violation of the Charter. They did so not by ruling on the case before them, and I highlight the facts that I read out, but inventing a new possible case to arrive at their politically motivated conclusion. Justice Mary Morrow, who released the majority decision, invented the reasonable hypothetical of a 17-year-old girl texting a nude image of herself to her 18-year-old boyfriend, who then shared it with another 18-year-old who held on to it for a while instead of just deleting it. Morrow said in this case, a 1-year mandatory minimum sentence for possession of child pornography would be cruel and unusual and violate Section 12 of the Charter. Therefore, she ruled that the mandatory minimum had to be struck down in all cases. The ruling, starting with the made-up reasonable hypothetical, is insane. No prosecutor is going to bring those charges in the made-up case that Morrow used to justify her actions. I'm going to pause right there, Mr. Chair, and remind this committee that I enjoyed a almost 2-decade career as a Crown prosecutor, and I can inform you what the Supreme Court of Canada didn't touch at all is the use of discretion. The scenario, the unrealistic scenario that Justice Morneau used in that decision, in my view, would never see the light of day in any criminal court. Police have discretion. They are the first line of intervention when matters are brought as a potential breach of our criminal code. In the circumstances before them, I can't imagine, as a former prosecutor, any police service charging this particular individual with 1 count of possession of child exploitation material. There are other charges available to the police service in those circumstances, but even if the police service of jurisdiction had decided to lay a charge and bring it to my attention or any Crown attorney in this country, I doubt very much we would exercise the discretion to immediately, because it's a hybrid offense, to immediately proceed to prosecute by indictment seeking a minimum 1-year penalty. It is ridiculous. It is extreme. The article further states, there is a world of difference between a 17-year-old girl voluntarily sharing an image of herself with her 18-year-old boyfriend and a 3-year-old being forced into sex acts. Morrow knows that, but she also philosophically opposes mandatory minimum sentences and invented a case to arrive at her conclusion. It's revolting. It's judicial activism. To use the Latin legal term, usurpatio legis, she has usurped the law and taken over the legislative function by bending the law to her view. Given that there is no appeal beyond the Supreme Court, Parliament should use the notwithstanding clause in a case like this, but Fraser is saying no. His words, we don't intend to override the Constitution to fix the problem. This is where Fraser and I disagree. Using the notwithstanding clause to overturn this ruling would not be overriding the Constitution. It would be overturning a bastardization of the plain meaning of the Charter. It would be telling the judge, 5 of them actually, that their job is not to bend the law to their own vision. It is to interpret the law as written. In the immediate term, the federal government should invoke the notwithstanding clause to put these 5 judges in their place. After that, Parliament should look to draft and pass legislation and guidance for the courts to restrict the use of reasonable hypotheticals. This valid tool of the court has seen rapidly escalating abuse over the last decade to the point that we arrive at this decision. Most importantly, Mr. Chair, in Canada's system, Parliament and not the courts are supreme. It's time for a government in Ottawa to act like that is the case to protect our nation's children. And I do want to highlight the comments by Minister of Justice Fraser. We don't intend to override the Constitution. The use of the notwithstanding clause, Section 33, is part of the Charter. There is no overriding here. So it is it's a interpretation that is not worthy of acceptance. Now, I do want to highlight, and I'm going to be wrapping this up very shortly, Mr. Chair, I'm going to highlight some of the language in the dissenting opinion. And I would note that 4 justices were part of the dissenting group that prepared this judgment, and that included the Chief Justice himself, Wagner. And he basically starts off by saying, our case law, meaning the Supreme Court of Canada's case law, is categorical. A mandatory minimum sentence does not necessarily violate Section 12 of the Charter. They say it as follows: the appeal should be allowed. It has not been shown that the minimum sentences provided for in Section 163.1 sub 4 and 4.1 of the Code constitute cruel and unusual punishment within the meaning of Section 12. The impunged provisions are constitutionally valid and operative. The censure of society and the law must be reflected consistently and rigorously in the sentences imposed on offenders who are guilty of sexual offenses against minors. Through the imposition of more severe sentences, the justice system expresses society's deep and rightful indignation. A fit and proportionate sentence is one that is consistent with the teachings of the Supreme Court's decision in Friesen, 2020 SCC 9, and that gives effect to Parliament's intention that sexual offences against children be punished more heavily. Thank you, Chair.
Thank you. For the benefit of witnesses, when a member makes a motion like this, we do have to suspend regular proceedings. I have no guarantee that we will get back to questioning till 5, so I do ask for your indulgence as we hear the motion. I recognize 3 of the Conservatives that had their hands up first, starting with Mr. Lawton, then Mr. Baber, and then Mr. Gill, followed by Ms. Latanzio.
I am really gobsmacked, Mr. Chair, and quite disappointed that this Conservative motion is necessary. When this Supreme Court decision came down last week arguing that a mandatory minimum sentence for the possession and acquisition of child sexual abuse and exploitation material was cruel and unusual punishment, I thought this could be and would be a unifying moment for members of Parliament and parliamentarians of all stripes. I actually had a moment of hope that the Liberal government would do the right thing here, say, this is ridiculous, we are going to reintroduce the law at the first available opportunity and do so using the notwithstanding clause, a key part of the Charter of Rights and Freedoms in this country to assert that Parliament, as the democratically elected body by Canadians, gets to have the final say on this and not an activist judge. And I'll speak to why, very briefly, the mandatory minimum is necessary in the first place. The 2 offenders that were at the center of this Supreme Court ruling had each of them hundreds of images of child sexual exploitation and abuse material, referred to in the decision as child pornography. One of them, 90% of the images were depicting young girls between the ages of 3 and 6 years old, some of which showing them being, quote, subjected to acts of penetration and sodomy committed by adults and minors. The other offender as well had hundreds of images and videos of children from 5 to 10, quote, being subjected to sexual abuse such as fellatio and vaginal and anal penetration by adults. Now, the judge at the trial stage gave the first offender the bare minimum, 90 days imprisonment to be served intermittently at his convenience, and 9 months of imprisonment. The second offender was given very similar, in fact, identical sentence there. Without a mandatory minimum, that sentence, which is already in and of itself offensively low, may have been even lower. That is why a mandatory minimum sentence is necessary. And that is why we are calling on this House to reintroduce this legislation with the notwithstanding clause. I was a victim of sexual abuse as a child. And to my knowledge, there are no photos or videos of that. And I hope that that will end up being true. Child sexual exploitation and abuse material does not exist on a computer screen with the person who possesses it only. There are victims, hundreds of victims of this. There is a market for this. The government needs to send the strictest possible penalty, the strongest possible message in denouncing this. This should not be a partisan issue. This should be something that every member of this committee, Liberal, Bloc, and Conservative, can support, regardless of what the Minister of Justice has said on this, that we call on the House to do the right thing and protect children. Thank you.
Thank you, Roman, and then Amarjeet.
Thank you, Chair. This is not only about kids already abused, raped, and exploited in these pictures and videos. This is about more kids in the future who will be raped because the courts fail to punish these perverts enough and thereby deter future perverts. We gotta go hard on this so we can kill this industry. I used to lecture on the Charter a bit, and I want to talk about the Charter here. What was the point of the notwithstanding clause? It was to prevent absurdity. Attorney General Jean Chrétien used the notwithstanding clause to seal the deal on the Charter. That's how it came about. And he specifically used an example for absurdity that the Supreme Court could come up with. It was a hypothetical. He said, well, for instance, what if the Supreme Court found that possession of child pornography was protected under the freedom of expression? That's the example he used. I think everyone in this room, even the Liberals, would agree that such finding would be absurd. Now, that's not the scenario we have, but it's close. Senneville pled guilty to possession and access to over 300 images of children, mostly girls between ages 3 and 6 being sexually exploited. Nod pled guilty to possession of more than 500 images and more than 250 videos, most of which were children between the ages of 5 and 10 years old, many being raped and sodomized. I'm disgusted by this, colleagues. Striking down the mandatory minimum sentence for each of the 2 counts is exactly the kind of absurdity that the notwithstanding clause was designed to prevent. And I say this as a lawyer in good standing in Ontario. This is crazy. This is precisely why Section 33 was inserted into the Charter. And I'm tired of the use of these hypotheticals every time that the court sees an argument of overbreadth. A first-year law student can come up with a hypothetical which would not make sense and render the law overbroad. You know what happens when there is a crazy scenario like the court considered to strike down the mandatory minimum sentence? There's common sense. The police don't charge. The crowns don't prosecute it. But these guys are monsters. And I'm proud of my colleagues, and I'm proud of the leader of the opposition for clearly saying that we're going to invoke the notwithstanding clause when we're in government to protect these children from these monsters, to prevent this absurdity that the Supreme Court has arrived at. But Attorney General Fraser is refusing to invoke the notwithstanding clause. He knows it's appropriate under the circumstances, but then he would have to be arguing against himself in court after the factum he submitted last month. So I ask my Liberal colleagues on this committee to do your jobs, to safeguard the law, to protect children. Call on this government to invoke the notwithstanding clause, to put these monsters who through their actions contribute to the rape and sodomy of children, to lock them up. Please do the right thing. Thank you, Chair.
Thank you. Mr. Gill.
Thank you, Mr. Chair. Thank you, Mr. Chair. As my colleagues have mentioned, the decision by Supreme Court of Canada to remove mandatory minimum sentence for offences related to child sexual exploitation is absolutely disgusting. The court ruled that a minimum 1-year sentence for these offenders is, quote, cruel and unusual. But what is cruel and unusual are the horrific and damaging acts these offenders committing against children. Child sexual exploitation leaves deep and lasting psychological and emotional wounds that can shape the rest of their lives. As parliamentarians, we have the utmost duty to protect innocent Canadians, especially children. That is why this committee must call on Liberal government to invoke the notwithstanding clause to overturn the Supreme Court's disturbing decision and to reinstate mandatory minimum sentence for child sexual exploitation. The call to use the notwithstanding clause in this case is not a partisan idea. It is supported by leaders from across the political spectrum at both the federal and provincial levels, who agree that protecting children and not offenders must be our priority. With this level of support, this committee must do its part. We must pass this motion and urge the government to act, to make it clear that Canada will always defend our children. Canadians across the country are watching and waiting for Parliament to step up. We hope the government will not stand in the way of the majority of Canadians and will choose to defend our children and not those who exploit them. Thank you, Chair.
Thank you, Mr. Gill.